Trust v. Bland, 1993. This decision, which was determined in the House of Lords of the United Kingdom, is widely regarded as setting the standard for passive euthanasia, as well as euthanasia globally analysis of the judgment in Common Cause v. Union of India, analysis of euthanasia by the court. Using a writ petition, Common Cause, an NGO, brought up the right to die with dignity once more before the Supreme Court. The organization asked that advance directives and attorney authorizations be made lawful, so that those who are terminally ill or in a persistent vegetative condition might exercise their right to do so. A 5-judge panel made up of the then Chief Justice of India, Deepak Misra, Arjan Kumar Sikri, Ajay Manikrao Khanwilkar, Dr. Dhananjaya Yeshwant Chandrachud, and Ashok Bhushan received the case after it was originally heard by a 3-judge panel. The 9-judge bench of the Supreme Court in Puttaswamy explained the privacy, autonomy, dignity matrix guaranteed by the Constitution of India under Article 21. The bench has drawn the right to die with dignity from this reasoning. Permission to issue advance directives and attorney authorizations to permit the suspension of ineffective medical treatment or life-supporting technology in cases when the patient is terminally ill or in a persistent vegetative state. In order to keep a proper balance between relevant legislation and medical ethics, the bench has also established rules that set forth how such directions may be carried out. The court established these directions with the intent to avoid any potential abuse of such directives. To provide a framework for the right to carry out these directions and get attorney authorizations, all judges have extensively examined the ethical, social, and legal challenges surrounding the idea of euthanasia and advance directives. For instance, the opinion provided by Chief Justice Deepak Misra for himself and Justice Khanwilkar begins with a philosophical discussion of the worth of life and the irreverence of a life devoid of purpose and dignity. He has referenced a number of writers, philosophers, and thinkers, including Epicurus, Hemingway, and Tennyson, who have advanced the notion that mortality is not an adversary, and that, rather than an undignified extension of life, a dignified death is a reason to celebrate. He has also considered the socio-economic concerns surrounding this matter, such as the stigma that may be attached to medical professionals who stop life support and the potential for abuse of such legislation by dishonest family members, underlining the significance of carefully drafting legislation concerning advanced medical directives. To deduce the right to die with dignity from Article 21, Judge Arjan Kumar Sikri also looked to Gandhian ideals, the teachings of numerous religions on human dignity, several international agreements, as well as Mill's idea of individual autonomy. In line with Dworkin's definition of a hard case, Judge A.K. Sikri categorizes it as one in which there are multiple legal options, and judicial discretion must be used in the service of the greater good. Additionally, Chandrachud J. has addressed the topic of euthanasia in light of the interlinkages between scientific knowledge, medical science, morality, and the fundamental ideals of individual autonomy and dignity enshrined in the Constitution of India. He has highlighted the importance of considering this right not only from an individual standpoint, but also from institutional, political, and social views with an eye toward the future. The best interest standard, which medical practitioners are expected to follow, has its roots in the Hippocratic Oath and Plato's writings. Judge Ashok Bhushan has taken a similar strategy and has mentioned various religious doctrines regarding life and death, in addition to tracing the history of the best interest norms. Additionally, in order to defend the right to a dignified death, every member of the bench has reviewed the legal precedents set forth by the Honorable Supreme Court, from the case of Prathanam to Aruna Shanbhag. To give an example, Justice Deepak Misra stated that the Supreme Court had made a distinction between the right to die and the right to die with dignity in its earlier judgments. While the right to die could only be drawn from the right to die with dignity in a very limited way, that is only in the manner of passive euthanasia, and only for individuals in a permanent vegetative condition. The former could not be construed to be a component of the protection of life and personal liberty under Article 21 of the Indian Constitution. Similarly, with regard to the court's decision in Shanbhag, Judge A.K. Sikri has explored the various kinds of euthanasia, as well as its philosophies, ethics, and economic history. A contrast between the right to die and the right to die with dignity has also been